All right, well, good afternoon, everybody. Thank you for joining us today. I am Margaret Richards, Director of Pro Bono Services at Husch Blackwell. Welcome to our final Alumni Academy webinar for the year. We hope that you have found these programs to be valuable. In the resources folder on the webinar console, you will find a link to the private alumni group on LinkedIn, as well as a link to Husch Blackwell's alumni microsite. We invite you to request to join the LinkedIn group and create your profile on the directory to stay informed of all our alumni and firm news, job opportunities, and special events, and more. If you have questions about the Alumni Network, please contact Stephanie Dorsum at 314-345-6646 or connect with her on LinkedIn. She is always plugged in, and she's pretty good at our LinkedIn stuff. She's pretty great at that. Before we begin, I'd like to cover a couple housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, we will be happy to answer those via email after. A PDF of the presentation will be available in the program materials folder. And this program has been approved for legal education hours. So for our attendees today, the report for your hours, or you can report your hours by clicking on the CEU icon at the bottom of the screen, and a certificate of your attendance will be, including the course materials, will be emailed to you starting tomorrow, along with a recording of the webcast for future watching and sharing should you want to. Toward the end of the program, be sure to complete a short survey. We use the feedback in these surveys to plan future programming that are applicable to your business needs. So please provide that feedback as we do use it. And that is all for the housekeeping items. So let's get started with our program. Today, we are excited to be discussing the ways that attorneys in different career environments can advance access to justice and create lasting and meaningful impact in our communities. And I'm very excited today to have Patrick Courtney join me. He is General Counsel at Terracon, and he's also the co-chair of the ACC Mid-America chapter of the Pro Bono Committee. So we'll do a little bit more in-depth introductions here in a second, but that's it for housekeeping items. And so welcome. Like I mentioned, I'm Margaret Richards, the Director of Pro Bono Services. I have now been at Husch Blackwell for the last 5 years. Prior to coming to Husch, I spent about 10 or 11 years as primarily an environmental litigator, although I did a little bit of transactional work and a little bit of regulatory work. So it was a really nice different buckets of hats that I wore that really allowed me to understand all of the different types of legal work and put that in practice, leading our firm's pro bono work nationally. So Patrick, I'll kick it over to you to introduce yourself to the group. And again, thank you for being here with me.
Yeah, thanks, Margaret. Glad to be here. And thanks, everyone, for joining us. As Margaret mentioned, I'm General Counsel of Business Operations with Terracon. I've been with Terracon for almost 12 years, and I started working on pro bono with the ACC Mid-America chapter in 2017. So over that time, we've kind of developed a program through the ACC that provides a annual clinic for our members. And we're now kind of looking, Terracon as a company, at expanding pro bono services and offerings for our attorneys and developing those programs. So very glad to be able to kind of share that journey and some of our experiences with you all today.
Yeah, that's great. And the idea for this, in talking to our friends over at the ACC, but also internally with our alumni group, was we have lost a handful of our pro bono champions internal. These are people that have just been such a delight to work with and are committed and passionate about pro bono that have gone in-house. And there was this original thought, well, shoot, I don't think I'm going to be able to do pro bono like I could in the law firm capacity. And I said, no, wait, stop right there, because there certainly are ways. And so you will hear a lot of that, or hopefully be inspired by what you hear today to know that pro bono can be done in-house as well. So you've heard kind of our introductions into sort of who Patrick and I are. Some of the topics that you're going to cover today are listed here. So for example, things like the why, right? Going into the justice gap and how there's a need. And then hitting on some specific things that really relate to the in-house capacity. Although, I mean, they also relate specifically to the pro bono or the law firm world as well. Patrick, do you want to cover some of at least highlight some of the things they're going to be hearing about when it comes to specific pro bono things to keep in mind in the in-house?
Yes, absolutely. We'll be talking about that multi-jurisdictional practice question, the ethics around that, making sure we're up to speed on rules, and then partnering with law firms is a big one that we're going to touch on as far as a strategy for developing those in-house opportunities, and malpractice insurance. How can you obtain that? What are ways that you can kind of clear that hurdle? And then just some general practice tips around how you can develop a pro bono practice as an in-house counsel.
Yeah, great. So, all right. So we're going to start actually with a poll question, keep it a little lively. Patrick and I are both interested to know from our audience today, have you had the opportunity or the ability to take on pro bono work in your in-house position? So I'll give you guys just a few seconds to respond with either a yes or no, and that'll give us some insight as to how many of our folks on the call today have been able to do pro bono. I feel like we should have worked in some fun music in the background. That's way beyond my technical skills, so I won't even attempt to make that work, but that would have been fun for these little, not quite Jeopardy music, but.
No one wants to hear me sing, so I'm not going to offer that.
All right, so it looks like we've got about half of our folks have been able to respond so far, so I might give it just a few more seconds. And maybe that's as good as we'll get today, is about 50%. So we'll see. Oh, it's still trickling up, so I'm going to give it just a little bit more time. All right, about 52%. So let's go ahead and advance and see kind of, and this is kind of what I would have expected to see. Patrick, I don't know if you would have expected slightly different numbers. It makes sense to what I've kind of encountered with working with different in-house companies across, not companies, but in-house attorneys across our footprint. And so we're going to talk about a lot of reasons why maybe there is a bigger no answer right now, and some solutions to maybe turn those into yeses. All right, so I think the most obvious place to start is sort of why pro bono is important. For most of our folks, and I would put this, the main reason does come down to a sense of beliefs or a sense of duty, right? We went to law school to make a difference in our communities and for those around us. And so it's that sort of driven passion to help. So I think ultimately that's what drives most folks, at least what I see internally here, with why they want to do pro bono. We certainly do see it, the why though, fall into professional development. Pro bono can be a really great way for folks to get skills early on in their career development as an attorney that they might not get as quickly in their progression of their career as they can with pro bono. So we see that chances for our associates in particular to go to trial, right? And to sit first and second year on trials really early on in their career. And there's also this sense of professional responsibility. And so what I've noted here is the ABA Rule 6.1. And when we talk about, when you see rules cited here today, other than we will highlight a couple state-specific rules, most of the rules that are cited here are going to be the ABA general rules. And so, of course, you'll want to double check what those look like and how your state has adopted that rule to see how it's applicable specifically to where you practice. The ABA Model Rule 6.1 does encourage every lawyer and says that lawyers have this responsibility to provide legal services to those who are unable to pay. And so the aspirational goal under the ABA rule is 50 hours of pro bono legal services a year. Not every state has adopted this rule in this full capacity. Some states changed the hour. So I think in Missouri, it's 40. Most states do select it at that 50-hour aspirational goal. And then some states don't have a goal at all, an hour goal at all, but they do say, I think every state has adopted this model rule to say pro bono is important and attorneys should give back. And so I will say a lot of states also have recognition programs that go along with this. So for attorneys who do pro bono work, they're going to recognize you for that pro bono work. So I know the Bar Association in DC honors people who have hit both sort of what they call pro bono honor roll for people that hit that 50, and then they have a high honor for people who hit 100 hours. In Missouri, we have the Pro Bono Wall of Fame. In Wisconsin, it's the Pro Bono Honor Society. So there's a lot of different state recognition programs that come out of this. All right, Patrick, do you want to take the lead on the next poll question?
Sure. So to go along with the prior question of just that yes, no, have you had an opportunity to do pro bono work? We're curious about what are some of the reasons, if you haven't had an opportunity to do that pro bono work in-house, why might that be? Lack of time is something that we hear pretty commonly. You're too busy with your in-house work, family commitments or other personal obligations, or a feeling that you don't have the skills or experience to take on certain of those pro bono opportunities, or it might be something else. So if you take a minute here to answer that question, that would definitely help.
I guess one that we didn't list here, which would fall into that other category, could be things too, like the feeling that maybe pro bono isn't accessible to you at the in-house capacity. And hopefully there's some things we can do to change that. But so yeah, so go ahead and take some time. We're interested to get the feedback as to why maybe that strong no answer on the second slide was where it was. Yeah, I'm totally going to figure out how to put music in. This is that awkward silence, right? I had an ADA professor or alternative dispute resolution professor in law school that said, get comfortable with silence and use it to your advantage when negotiating. As you can see, I can't even be quiet while I'm waiting for people to respond to this important poll question.
Yeah, the silence doesn't bother me, but it looks like we're at about 54, 57%. So that's some good feedback for us here, and a good spread. It looks like, among the different reasons. And for those that answered other, we may call out, some of those other reasons that you might have come across for not being able to take on that pro bono work. So yeah, let's take a look at our results here. So pretty even split between lack of time and other. So although now that I'm looking at this, I'm not sure how those percentages quite add up, but one way or another, we've got some data here to go off of. So thank you for taking the time to answer those questions.
Oftentimes lawyers aren't the best with math. That's my probably the least strongest suit. So yeah. You're right. Those numbers don't make a whole lot of sense. Yeah. Oh, they can select more than one. Okay. So that's why some of that makes sense.
Good.
And that's probably true, right? All of those could probably apply at any given time. So.
Yes, I know those things have definitely come across my mind when I'm thinking about pro bono as, some of the challenges. But some of the others, and I've dealt with all of these myself. And when I'm talking with other individuals about pro bono and how do you make that happen in an in-house capacity, one of the things that first comes to mind is insufficient resources. your practice in-house is a lot different than your practice in the law firm. You don't have the same resources to take on individual matters, and you feel like, how would I even go about that? Malpractice coverage is another big one. And we'll get into all of these in a bit more detail later, but that's certainly one where folks kind of say, well, I need to make sure that I've got the coverage, and you definitely do. The licensing requirements, like we mentioned, and different states have different requirements for those, so you want to make sure that those are covered. Concerns about competency. And then one of the big ones from an in-house perspective is, will the company support your time spent on pro bono, right? Because when you're working at the law firm, that's kind of ingrained. Everyone understands what pro bono work is, why it's important, and the opportunities are a little bit easier to come by. Your company may not have that same sort of understanding of those aspirational goals that Margaret mentioned within the rules that we need to be working towards. And so that might require, some conversations about, what we need to do in those capacities with our company leadership. And then how do you find those pro bono clients, right? When you're in-house, you got your client, the company you work for. And so you don't have that constant influx of that variety of clients. You may not have someone dedicated to finding those pro bono opportunities. So it might be kind of up to you to figure those out. So individually or all together, these reasons for, having difficulties with pro bono can really feel overwhelming. The good news is there are answers for all of these questions and resources that can help you overcome those. But aside from the specifics, one of the things that I think is helpful is just from a mindset perspective, reimagining what pro bono looks like, understanding the differences between in-house and law firm practice, and kind of taking a look at, okay, well, what does pro bono look like in the in-house context, just so you can get a different perspective on it. Really think in terms of partnerships, because those partnerships with law firms, with LSOs, with law school clinics, with organizations like the ACC, those can really provide avenues that will answer a lot of those challenges for you and help you to overcome those. And then find causes that are personally meaningful for you. If you've got that personal incentive to say, I want to help this organization, or I want to help this group of people, that'll give you that extra boost to say, okay, I'm running into some roadblocks here, but what are some ways that I can overcome those challenges?
Yeah, that's great. And just kind of picking up what you were talking about in terms of partnerships, that is so key. And, in recognizing that there may not be a full-time a full-time pro bono person like myself in-house. Now, some in-house, some companies actually have gone to, there is a movement to have sort of a full-time pro bono person help lead the legal teams at your really large corporations. So that there can be valuable pro bono, but not every corporation has that resources or that ability to have a full-time person. So really thinking in terms of how can we partner and who can we work with to make sure that there's sort of a pipeline for the pro bono work in our communities.
Yeah, and the other thing that I would mention on this is, Margaret, you talked about a lot of times within the law firm context, the pro bono opportunities are ways for less experienced individuals to get some of that experience. On the in-house side, pro bono opportunities can be a great way to kind of flex those muscles that you've developed that maybe you don't get to use as much in your in-house practice, and kind of get back into some of those things, use that skill set that you had used previously at the law firm. So that's another way to look at it.
That's great. I actually hadn't thought about that avenue, and that makes complete sense.
So those are some of the challenges. And Margaret, do you want to touch a little bit more on the justice gap that you had mentioned previously?
Yeah. So the Legal Services Corporation puts out a justice gap report every few years. And so this report actually just came out within the last month or two. So this was fresh off the printers, right? If we weren't in an electronic world anymore and people still printed stuff, this report just came out. And under the most recent report, it found that 92% of low-income Americans were not getting assistance for their civil legal needs. This was an increase. That number in the previous report was, I think, 85, 87. So there certainly wasn't an increase in that. which is not surprising given that we just came out of a pandemic that resulted in a lot of legal issues for folks thinking about some unemployment type stuff, landlord tenant type stuff that really came bubbled out because of COVID. And so most of the most common legal problems that fall into this category are things like consumer issues, healthcare, housing, so the landlord tenant stuff, but also income maintenance. So really programs that are out there to help folks. So when we talk about income maintenance, it would be things like access to SNAP benefits, to make sure that low income folks have the ability to put some food on their table if that's not something they have easy access to. The report also found that legal aids across the country are unable to provide any or enough legal help for an estimated 1.7 million civil legal problems that come their way in a year. So these are people who are eligible for legal aid, meaning they meet the percentage of the federal poverty level to get into a legal aid for their help. But the legal aid doesn't have the amount of resources and availability to take every single case. And so this is really where law firm attorneys and in-house attorneys can really roll up their sleeves, so to speak, and get involved to really help bridge this access to justice gap and help even more people. So back to you, Patrick.
Yes, so we talked about some of those challenges and how to overcome those. So let's get into a little bit more specifics. First, on the question of multi-jurisdictional practice. So different jurisdictions have different requirement for pro bono services for those who are non-locally licensed. And what we're referring to in this case is many states have what is commonly referred to like a corporate license, where basically they're allowing you to practice in their state as long as it's only for the corporation that you work for, the business that you work for. So you're licensed on a limited basis to provide those services, which raises the question then, what restrictions might apply to you when you're trying to provide pro bono services in that state where you work. So a lot of states will have restrictions on those or certain guidelines. Some are a little bit more open, but that's just a handful of those states. So it's important to know what your state requires if you do have that limited license. So just a quick rundown of some of the different kind of flavors, if you will, that you might get as far as rules around in-house practice of pro bono. There are 18 jurisdictions that allow out-of-state attorneys to provide pro bono services following a major disaster. So those would be things, of course, like hurricanes, earthquakes, floods, that sort of thing. So if you're in one of those jurisdictions, you can take advantage of that as a possibility. 30 jurisdictions allow pro bono services by non-locally licensed in-house counsel. 20 jurisdictions allow for active attorneys licensed out of state to provide pro bono services. And then 47 jurisdictions permit retired attorneys to pro bono services. So that's kind of the different avenues that you can pursue depending on your location for providing pro bono in-house. So we're going to get into a few more states specific, and we're trying to cover the states that are most applicable to our attendees. If you are in a state that isn't covered here, let us know, and we'll get you some of those specifics. I don't want to go through each of these in great detail, but I did want to note, since Illinois is the first one that we have here, they, along with New York, Wisconsin, and Virginia, are the 4 states that will allow in-house counsel to provide pro bono public services more broadly. They also have a rule on out-of-state pro bono services. Now, one of the overarching themes that I would recommend as a strategy if you're considering, starting a pro bono program within your company is take the time to kind of sort out the details before you really dive in. And this is one of those that really applies on the multi-jurisdictional practice side of things. And specifically, and I'll use Kansas as an example because that's where I have my corporate licensure. We note here that in-house attorneys are permitted to provide pro bono legal services through an approved legal services organization or an accredited law school clinic. But there's a little bit more to the story. You have to fill out some forms. There have to be some approvals. So really make sure that you get into the details of your state's rules in each of these circumstances so you kind of understand what's going to be required And it may not be the kind of thing where you can just call up legal aid and say, hey, I've got some time tomorrow afternoon. Can I, come do some pro bono work for you? It might take a little bit more prep work before you can get into those services. So we've got Illinois, Kansas, and Missouri covered on this slide. Colorado, Kentucky, and Minnesota on this slide. You'll note that Colorado, like Illinois, has a rule on out-of-state pro bono services. So that's something to note for that jurisdiction. And then Tennessee and Wisconsin, again, Wisconsin being like Illinois in having that broader allowance of pro bono services. Margaret, was there anything you wanted to note on the multi-jurisdictional practice aspect?
Yeah, I would just add, some of these rules are relatively new. I think I think back to the effort in Kansas in particular, to add in this exception to allow in-house folks or those who work in-house that are licensed elsewhere to be able to do pro bono work. There was a big push in the state of Kansas within the last 5 years to put a rule like that in place. And so if you don't have a rule like this, or you would like to see your state maybe broaden its provisions like Illinois has done, get a hold of the group. Going back to partnerships, right? Find others in the ACC and law firms that will get behind that to advocate for rule changes. I know in Kansas, our law firm was actually part of that effort to really support that rule change to allow in-house folks to take on pro bono, specifically in partnerships with legal service providers in the state. And obviously, as you can see on the slide you saw earlier today, that was approved. So just know more can be done on this front, and we can partner together to try to advocate for rule changes as may be needed. All right, so along those same lines, one of the things that sometimes comes up when we're talking about the ability to do pro bono work and sort of, and this could be time, right? We heard from some of you guys earlier today, maybe you don't have a lot of free time to be able to do pro bono. And so one solution to some of that is under what's called the clinic rule. I call it the clinic rule. It's really not the official name for this, but it's this idea of a limited scope or a limited clinic atmosphere. And this is really a good way, I think, for in-house attorneys to engage in pro bono. This is also a really popular way for our in law firm attorneys to engage, because many of my attorneys, especially our partners in particular, may not have time to take on a full case, but they do have time to go to a very specific clinic, a very specific bottled up time frame to do a limited scope opportunity. And so under this rule 6.5, lawyers under these programs, and it's almost always required that they be sponsored by a nonprofit organization, a court. So think of things like partnering with legal aid or the Access to Justice Commission in the state where you practice will put on these limited scope clinics. It might be an advice only clinic. It might be something that's targeted to like a state planning where you go and you prepare just the healthcare directive that day. And so when you walk out, you're not continuing to represent that person. You're helping them in sort of the clinic rule, the four buildings of that clinic. Or in a virtual world, which is what we see now with these. And so under this rule, it does say that the attorney-client privilege is created, right? It is established in these situations, but there is no expectation that that representation will continue beyond sort of that clinic itself, that one-time consultation. This does require, though, that we do get informed consent. In the 5 years that I've been doing this at Husch, this has always actually been handled by our partners, our legal aid partners, or the different access to justice commissions we're working with, or the different courts. They're handling that part of it. It's usually a one-page document that the client signs. And then under this rule, there also is typically an exception for conflicts checks. Right? Because of the nature of a clinic work like this, you're not always going to know who's going to show up that day that's going to need that advice or that immediate consultation. And so there usually isn't an opportunity to do a full conflicts check. And so under the exception to this, the attorneys are able to do that work unless they have actual knowledge that another lawyer associated with the firm, or in this case, the company, is representing that client. So just kind of some things to keep in mind. Not every state has adopted this. I know most of the states where we practice, where our attorneys are located, have a rule or at least a similar rule to this. Anything in particular, Patrick, that comes up on this rule that specifically to keep in mind for the in-house world?
Well, yeah, my feeling on clinics is it's a fantastic way to get started down your in-house pro bono journey. I know for me, the clinic was the thing that finally made me feel comfortable enough to overcome all of those concerns that we talked about originally, because like you mentioned, the scope is going to be, limited representation. So you don't have those questions out there of, how long might this take, and having that be an unknown. You get to make sure that you feel comfortable with the type of matter that you're going to be dealing with. A lot of times you have an opportunity to partner up with a firm attorney, so you've kind of got that expertise that you can pair with, who has the resources that might be necessary. And so this is a great way to kind of dip your toe in those waters from an in-house perspective. And so looking for clinics, I would highly recommend as a first step.
Yeah. And that's a great point you just made, that we've had really great experiences partnering in particular with some of our ACC colleagues in most recently in St. Louis. To do a pro bono clinic like this. So there were ACC folks, there were Husch Blackwell attorneys, and then also Legal Services of Eastern Missouri. And it was really a chance for in-house lawyers to work hand in hand with firm lawyers in a capacity that's not sort of all about the business, right? It's a way to give back and work with somebody in a little bit different of an environment, and was very meaningful for our folks. And it was through a program like you would see with this limited scope clinic rule.
And a lot of times, because of the number of organizations that are involved in that can be your avenue to getting malpractice insurance for that limited representation as well. So a lot of times the clinic can provide that to you if you don't have it.
All right. So I always think, and this goes back to, of course, one of the reasons folks maybe are not taking on pro bono work, and what Patrick just said about using a clinic to maybe gain some of that competency in an area that maybe isn't something we normally do. I do want to encourage our folks, and I say this to our law firm attorneys as well, to get out of your comfort zone, right? A lot of the needs in the pro bono world are not the same needs that we see in our business world. Now, sometimes it is, right? If you're a transactional lawyer and your bread and butter maybe is IP and you're doing trademarks and copyrights, there certainly is pro bono along those lines, and it's well within your wheelhouse, but oftentimes it may not be in your wheelhouse. So I do want to challenge you through pro bono to be able to take on work. And of course, there's an ethics rule that gives us guidance on how that works, and to make sure that we're competent when you do take on something outside of your typical skill set. So follow Rule 1.1, right, which states that a lawyer shall provide competent representation to a client. And to get that competent representation, it means we're doing all of the things that as lawyers we know and learn how to do, right? We gain the legal knowledge. We work for skills and thoroughness and preparation to be able to do that. One way that I look to do this internally, and this goes back to partnership, I think that's kind of a theme that you're hearing today, is this is also a great way, and why it's important to work with legal aid providers across the country. Oftentimes when we take on some of these big projects, we rely on their subject matter expertise because they really are maybe the experts in that area. And so they come in and they provide training and resources and mentorship along the lines if you are taking on something that's maybe not your typical wheelhouse. And of course, I had to throw in a quote from Ted Lasso, that taking on a challenge is a lot like riding a horse, isn't it? If you aren't comfortable doing it, maybe you're doing it wrong. I encourage you all, if you haven't seen Ted Lasso, it's a very good show. And this quote just hit perfectly that I had to throw it in here for you all. So hopefully the humor hit home for everybody with us today.
I certainly second the endorsement of Ted Lasso. And for me, on the competency question, I really try to focus on the scope of representation, like we talked about previously, and making sure that's well defined, as kind of establishing my comfort and the client's comfort in knowing that we're not going to be delving into areas where I don't feel like I can provide competent representation. And a lot of times we'll have opportunities with new nonprofits, and they'll say, I need board governance docs, I need nonprofit certification, I need help with this new lease I'm entering, and I need an employee handbook. And you say, well, okay, I get that you need all that, but I'm not the person that can provide it. So if you make sure and say, okay, we're going to focus on the lease document and the employee handbook, but those other two items aren't going to be part of this scope of representation, that can really help in making sure that you are clear on what is going to be there and what's not going to be part of that. And so you don't run into those competency concerns.
Yeah, and that's such an excellent point, because we see that a lot, right? And you'll hear actually later on, there's a slide where we talk about some different tips and tricks. And one of those is to sort of have this idea of empathy with working with low-income folks. And that's because a lot of times this isn't their only legal issue they have. And so that also applies to what Patrick was just saying with nonprofits. They may have all kinds of legal issues, but having a really good, well-defined retention letter or engagement letter that basically says, this is what we're doing, this is all we're doing, is really important. That doesn't mean you can't agree to take on that other work later on. It's just each and every time we do a new engagement letter that defines that. And so you kind of know exactly what you're getting into, and do you have the competency to do each of those each time. Which leads, I think, right into sort of this, what you need to keep in mind when it comes to positional and business conflicts. We certainly see it in the law firm area. And I know, Patrick, I'm going to turn it over to you to talk a little bit more how this specifically might come into play in the in-house capacity.
Sure. Yeah. And this is one of those where we talked about previously, just kind of shifting that mindset of, how do we look at some of the same concerns in a different way when we're in-house? And so conflicts are something that we definitely need to be aware of, but they might kind of come up in a different way than they would have in a law firm context. So, wanting to see if there are certain company policies that might be violated if you took on a certain assignment, if there are competing business interests that your company might not want you being involved with in a pro bono opportunity. The specific example we have here is, banking institutions not having volunteers handle certain consumer law related issues. So those are things that you need to kind of understand, from a business perspective, where might it be, an area that I should avoid, or client types that I don't want to take on a pro bono opportunity with, which is a bit of a different focus from the law firm perspective.
Great.
So Margaret, do you want to touch a little bit more on the pro bono partnerships that we've been chatting about a little bit?
Yeah, so when we look at pro bono partnerships, this is one way that is going to help address some of those concerns that maybe are preventing you guys from being able to do pro bono work. And there's lots of different ways to do these, and some different things to really keep in mind as you're doing them and why you're doing them. So I think one of the biggest things to start with is to try to align pro bono interests, right? Your attorney's interests, the company's maybe position and sort of ultimate strategic plan when it comes to community service and pro bono and things like that. But those things also need to align specifically with the critical needs of the community. And so to be able to kind of figure that out and address that access to justice gap is to really develop these partnerships with our legal aid partners. And so you see some of the possible partnerships include, working with law firms directly, right? There's lots of ways where we can team up together to bring forth a specific pro bono clinic or project or take on a case, things like that. So there's ways to do that directly. But also, I think the biggest probably comes from working with LSOs, so our legal services organizations, partnering with programs like and groups like the ACC chapters, the bar associations, access to justice committees that courts have, and also other internal groups. And so what I mean by that are, can you partner with maybe your employee resource groups or your affinity groups on some different maybe initiatives or focus pro bono groups specifically on those, right? And so just kind of developing, what do we want to do? How do we want to do it? And who should we do this with? But I think once you kind of have decided all of that, I think it's important to also make sure we're defining those expectations, right? Having a really good understanding of who's doing what, how are they doing it, who's taking the lead. This is probably mostly important if you're joining up to take a very impact litigation or a very specific litigation case. And let's say we're partnering with an in-house and a law firm attorney to do that, knowing really who's taking the lead on things so that something isn't falling through the cracks and one person is thinking the other person is doing it, right? Really having that open communication and that set of expectations as to how that partnership's going to operate. I know we certainly have partnerships here at the firm where we actually go into a memo of understanding with the group that we're going to be partnering with as to how that's going to look, right? Who's going to do what, how we're going to do it, how we're going to report it, how we're going to report out information and things like that. And so I think just keeping in mind how these partnerships can really enhance the relationship between the parties that are entering into that is such a good way to create successful, but also sustainable and meaningful pro bono partnerships along the way, right? So I had given the example earlier where we had partnered with ACC and LSEM in St. Louis, and that just really bonded, I think, our attorneys with the in-house attorneys that they work really closely with on the business side of the firm in a way that was meaningful to them and giving back to the communities. And so you could just see the growth that came out of having a strong partnership like that. Which I think leads into one of the main reasons we do these partnerships, especially with LSOs, so legal services operators or organizations, is specifically because one, it brings with it training and resources, goes back to that competency slide we talked about, but it also often brings malpractice insurance coverage. And so I know here at the firm, we, as part of our malpractice policy, we cover pro bono, right? And so that's covered as the firm umbrella policy. That may not be the case everywhere. And so I'm going to turn it over to Patrick to talk a little bit more specifically, but that is one of the main reasons it can be very beneficial, both in-house and for law firm attorneys to take on projects specifically with legal aids, is it can be a good way to cover that malpractice insurance.
Yeah, thanks, Margaret. Before I jump into this anymore, can you all hear me okay? I know we're having some issues on my audio.
Yeah,
okay,
it sounds
good.
Much better on my end, yeah.
Okay, great. So yes, malpractice insurance is definitely one of those issues that creates those challenges. And it's not always something that's covered by your malpractice insurance. But there are a few different avenues that you can take to answer that question and make sure you do have that coverage for those pro bono opportunities. The first thing I would recommend is just see if your carrier will add it to your policy. A lot of times they'll do that free of charge. Sometimes there might be a charge. For my company, our carrier added it without any charge. But to give you a little bit of context, I work for an engineering company, and I think the carrier was looking at it like, we already cover, design work on deep foundations for 40-story high-rises, so we're not concerned about the added risk of limited pro bono legal services. So they added that on there without an additional charge, but that may not be the circumstance that you all run into in your instances. The other thing is keep in mind with legal aids, other LSOs, they may be able to provide coverage for those pro bono opportunities. And then within your ACC chapters, they may be able to provide in-house coverage or malpractice coverage on a limited basis. Those are good avenues for those individual instances. But if you're looking at building a more long-term and continuous in-house pro bono program, you might want to look at having something that will cover any of those instances, so that you're not worrying about checking off that insurance box with every opportunity that you take on.
And I see the slide here. We reference NLADA, and just for those who may not be familiar, that's the National Legal Aid and Defender Association, and they do specifically have insurance policies out there available as for malpractice, should folks need sort of a new policy or a specific policy. Not that I'm promoting specifically NLADA's policy, but just as an example that things like that are certainly available if needed.
Yes, and it's good to know all of those different resources, because depending on the circumstances, it's good to have all of those options. So we've talked about some different opportunities or different ways to consider in-house pro bono practice, and one of those things to kind of look at is developing a program at your company to make pro bono more of an integrated part of what it means to be an in-house counsel at your company. So some of the things that you can do there is decide, do you want to create a pro bono policy? Do you want to have that managed by a committee, a pro bono coordinator? The questions there kind of depend on what's the makeup of your department. I was at a panel discussion recently on in-house pro bono, and it included the general counsel from Amazon and the general counsel from Cisco. Obviously, those are enormous in-house departments, and so their resources are a lot different than, say, mine, where we have 8 attorneys in-house. And so what a pro bono program is going to look like for us at Terracon is going to be a lot different than what it looks like at UPS or Amazon, or a place that really kind of is running their own, kind of small to large law firm themselves. So understanding kind of what the makeup is of your department, the individual goals and skill set of the members of your team, that's going to be important in kind of crafting what you want your program to look like. The one thing to keep in mind is tracking the pro bono is going to be important for this to be developed. I've kind of thrown out, different opportunities that I've kind of seen come up without a whole lot of success. But if you make it something where you're saying, this is something that we want to do as a department, and this is something that we're keeping track of, and that's going to make a big difference for people to be looking for those opportunities themselves, thinking on their own terms of, what do I want to have this be for me as an attorney in my own pro bono practice. And so that's going to be important in really getting that off the ground and moving in a continuous direction. Factor in, you want it to be part of the evaluations. Is it going to be that robust part of your program where you're saying, as we're looking at your overall performance, are we going to be taking a look at the pro bono hours? That's an opportunity. I think recognition is a big one, right? And that gets back to what we talked about earlier, as far as making sure that your company leadership is on board with this, really promoting to them that say, hey, we want to develop this program, and we'd love if you provided some sort of recognition, whatever that would happen to be, whether that's general participation or individual that participates the most, any of those sorts of things to incentivize your folks to participate in pro bono is going to help bolster that program and have it be something that you can continue long term.
Yeah, and I would just pick up on that too. Speaking of recognition, going back to the slide where we talked about the ABA model rule, right, on doing pro bono work, and I mentioned that some states have honor societies and things like that. If your organization has a CSR report, or they're putting sort of press out there. I know we internally see a lot of great traction when we get to talk externally about our firm's pro bono work and what our attorneys are doing. And so to be able to highlight, hey, we had, 57 attorneys in Missouri recognized for their pro bono work. So it may not only be internal recognition, but how do we also get the word out that we're doing such great things in our community? Not that we do this to put our pat on the back, pat ourselves on the back. That's certainly not our motivation, but there's lots of different things that could come up. And I would just add, when we're looking at things like pro bono policies and how you set up maybe a pro bono committee, if that's appropriate for a larger organization that you might have, this is also where some of those partnerships can come in handy. I know we have internally provided sort of outlines and information to in-house folks, what our policy looks like, or access to what other pro bono policies look like in corporate legal departments. And so there's a lot of information sharing that can happen in the pro bono context. Ultimately, you know, we're all lawyers. We sort of have that competitive feel. We all want to develop business and excel in that. But when it comes to the pro bono world, there's so much work that so many people need help, that you don't really need to fight over these clients, right? Like there's just a steady flow of how to do that. And so I feel like in the pro bono capacity, it's very collegial and collaborative. So if there's anything you need, you want to see example policies, you know, don't be shy. Feel free to reach out to your law firm folks. Me in particular, you know, whoever it may be, wherever you may be sitting, there certainly are folks that are willing to help when it comes to developing these types of programs.
And one final thing on this, I'd like to share the advice that we received from the Ohio ACC chapter when we were looking at developing our chapter's clinic, which was, don't rush it. If you're starting from scratch, don't feel like you need to be in a hurry to, you know, implement and roll out an in-house pro bono program. Take the time to really decide what you want it to look like. Get those details figured out, because each one of the members of your department are carrying one, if not more, of those concerns that we've talked about previously today, and some of you shared with us yourselves. And so taking the time to tailor this, answer those questions, having that comfort level is going to get you greater buy-in from the folks in your department and allow this to be a success. So don't rush. That would be my main advice.
Yeah, that's great. So I quickly wanted to hit on a concept or dealing with clients with diminished capacity, in particular because I see this particular rule come up more often in the pro bono context than I do in our typical billable work. And so that is under Rule 1.14, and it just says that attorneys need to, as much as reasonably possible, maintain that normal attorney-client relationship when you do have a client that might have some capacity issues. But if it does become clear that client's mental capacity is diminished, whether it's due to age, mental impairment, or for another reason, there are some steps that might need to come into play. And in particular, do you need to seek appointment of a guardian, a conservatorship, those kinds of things. I know for us internally, we usually see this come up with, you know, working with somebody who might need, for example, estate planning. And it's somebody who maybe isn't quite always there with her mental capacity, might come in and out. When and where can you actually represent that person versus when are you going to need an intermediate when you're going to need somebody else assigned to help. So just kind of something to keep in mind, because this is a particular rule that does, I think, impact pro bono work maybe a little bit more than some of our other typical ethics and professional rules that come up. We also wanted to cover, and we're getting pretty close to the end here, some tips for dealing with low-income clients. And again, these are things that I have seen over the years that are a little bit different, a little bit nuanced with dealing with pro bono compared to your typical attorney-client relationship. And that's, first of all, remember that most of the pro bono clients that we work with, especially if it's a partnership through legal aid that our clients are coming to us through, this is probably not the only legal issue these folks have. This is probably not the only crisis that they're dealing with. And so convey empathy and respect, but that also means to be flexible with them, right? I think oftentimes with attorneys, and certainly when we have to go to court, we're very keen on, you're on time, you show up on time, you do your things on time, and just know that that may not always be the case for our pro bono clients. And so there needs to be some sort of flexibility sometimes with that. And just know sometimes the pro bono clients may be harder to reach. They may not be able to pay their cell phone bill that month because it means they needed that money to put food on their table. And so having alternative ways to be able to reach them is good, right? Knowing, do you have an email where we can reach you instead? Do you have a work number or a cell phone or different things? And I would say be persistent, right? This isn't a one and done. Well, I called them one time, I left a message and the person never called me back, so we should close this. It may take more than that. But along those same lines, if you aren't getting responses back from the pro bono clients after you have made that diligent effort to reach out, that's when we're going to let our legal aid partners know, or our other partners know that, okay, I think it's time to close this. And then you should have a policy or a procedure internally on how to go about that. And I've got some other tips here, sort of thinking about the barriers that a pro bono client may have. And so if it is something where you're meeting with these folks on your own company site and you do have pretty extensive security that they have to go through, just know that may be something they're not familiar with. Maybe they've never been in that environment before, and it could be a little daunting. So if you have some of these barriers or some of these things, do some things like meet them in the lobby and kind of walk them through to your conference room space. Just those little tips that make it a little bit more comfortable, a little bit more easy as you're working with pro bono clients. Anything you want to add to that, Patrick?
No, I think that's all great advice, and having that awareness around where your client is coming from and what their needs might be is really key to having that representation be successful on both sides.
And so one of the last tips you saw on the last slide said, thinking about barriers, one of those barriers could be understanding of the language and just the legal court system altogether. And so working with interpreters, I think these are just some other good tips and best practices to keep in mind. Don't hesitate to hire an interpreter if needed, right? The pro bono client may speak English, but they also may be more comfortable in another language. For example, we recently did a really big project to help Afghan refugees with asylum work. All of that, many of those folks, well, I wouldn't even say many, maybe 1/3 of those folks did speak English and were comfortable with English, but we still had an interpreter for everything because it just brought a whole nother comfort level to the clients. I would say always use an interpreter when you're talking about taking somebody to court or dealing with very substantive meetings, just because legal terms and the legal process can be very confusing. And avoid using family members. That really hits more on, I think, confidentiality issues and things along those lines to keep aware of. This next one, I feel like this is one of those where I say my recommendation. What's the phrase? But I don't do it always so well myself. And so maintain eye contact with the client, not the interpreter. A good example of that was last week I helped as an election worker. I had a gentleman come in with his kid. The kid was signing. The father was hearing impaired. And so the kid was signing, and I was providing directions on how this gentleman could go vote and where he needed to go vote. And I completely failed this and looked right at the kid and not at the dad, and had to really be conscious that, everybody at this table is a human being and really should be treated and recognized in a better fashion than I did that day. So just some tips and tricks that when we're going through when we might need to use an interpreter. All right, and this is, I think, our last slide before we get to, open it up specifically for questions. And so hopefully you've heard many of these things today. And I know Patrick and I will kind of toggle back and forth maybe with some of these last takeaways. And so you've heard us talk about engagement letters, running those conflicts when you need to, unless you're in that sort of exception for the clinic rule. And again, making sure that scope of engagement is pretty clear and narrow in the engagement letter.
Right, and hold on to the documents and the client communications like you usually would. The question about recording your time, is that something that you want to make part of your pro bono program? That gets back to having that discussion with your company leadership about, hey, we want to do this, but we've got these family commitments and these sorts of things outside of work that don't let us take this on, we'd love to be able to record our time associated with this pro bono work. And then 18 jurisdictions actually allow pro bono hours to count towards CLE. So if you're in one of those jurisdictions, definitely take advantage of that to where you can be providing that great service to the community and also getting your CLE hours.
Yeah, and going back to recording your time too, one thing to keep in mind is I know a lot of partnerships that we do with legal aids across the country oftentimes will ask us for that. Can you let us know how much time you gave on this work, and is this case complete? And I know a lot of times they use that for their audits that help them establish how much resources and money they get to operate. And so just kind of keeping that in mind, like how you can manage that internally, especially if you're in-house and maybe you don't have the same timekeeping requirements that law firms might have. And I know we didn't leave really any time for questions. I'm happy to stay on and answer some questions if you guys have some and if you've put them in the chat. I know we had one in the chat earlier about malpractice insurance and sort of how that's impacted the ability to maybe take on pro bono. Hopefully we've answered that today. We can certainly elaborate on that more offline too, as needed. So I might give it a minute or two for some questions, but back to my housekeeping list of what I might need to cover with you guys for closing. Obviously, I'm pretty sure I can't speak for Patrick, but I'll throw this out there. You know, if you do have questions that come up after today, I'm sure both of us would be willing to follow up with you about how to bring pro bono in-house and how to make that work and how to maybe partner together. So we're excited and thankful that you guys joined us today. Couple housekeeping things that I will cover real quickly. Again, thank you for joining. We hope that this information was helpful and useful for your organization. As a reminder, this program does have legal education hours that you can report and get credit for. Click on the CEU icon in the bottom of your screen. A certificate of attendance will be emailed to you along with the materials for this session, as well as a recording. And be sure to complete our survey, because again, that we really do use that to plan out future programming. And before I officially conclude, Patrick, thank you so much for joining me today and sharing your experiences with in-house, both at Terracon and at the Association of Corporate Counsel. So thank you. Appreciate it.
My pleasure. Thank you for having me.
All right. Well, this concludes our webinar. So thank you for joining us today. Have a good weekend and have a great holiday with family and friends next week.